everyone in the room with us here at Touro Law School in Central Islip, New York. And good morning to those joining us online for day 2 of the conference, Disability Rights and Inclusion, the 3rd annual conference. And it's such an honor and a pleasure for me to welcome you here again. Today, I'm Sam Levine, Professor of Law and Director of the Jewish Law Institute here at Touro. Before we start today's proceedings, I would like to thank our sponsors and several generous sponsors who have offered your generous support, allowing us to put on this terrific conference. They include Immersive, Walmart, the Center for Community Inclusion, Sir Tillman Bowen, Hidden Disabilities, Rockstar X, the Dr. Basil Goralnik Bernstein Tzedakah Fund, the Ira and Andy Rafelson Charitable Fund, and Teachability Publishing. And I thank once again the Touro Law Review and the Touro DALSA, Disabled and Allied Law Students Association, for co-sponsoring and co-organizing the conference. And once again, thank you so much to the Dean, the staff, the faculty, and the students here at Touro for all of your work in making this conference such a success. I'll now ask the panelists for our first panel today to approach the front. And I'll turn the proceedings over to my colleague, Professor Rena Seplowitz, who is the advisor of the Law Review. And Rena, thank you so much for your co-sponsorship and all of your work in partnering with us.
We have a very interesting panel this morning on religion, and every year at the Disability Conference, we do try to integrate religion and connect it with disabilities. Can you hear me? Our first speaker is Solange Captan, who is an attorney who has years of practice in special education. Currently, she has her own firm, which is dedicated to special education, and in the past, she has been the general counsel to the Sinai schools, which is a program for special education in private schools and in many religious schools as well. And before that, she was with the New York City Department of Education's Office of General Counsel. So Solange, welcome back. And both of our panelists have been loyal supporters of this conference and have spoken here before.
Jocelyn? I'm not sure why it looks like that. It's okay, not a big deal. We can go to the third slide if you like so. Oh, there we go. And then do I just press this one? Exactly. Okay, perfect. Thank you. Oh, this way. Great, thank you so much. Yeah, we're good. All right. Thank you. Good morning, everyone. Thank you for that introduction. I wanted to first thank Touro Law School and especially Professor Levine for this amazing opportunity and putting together this great conference that's dedicated to disabilities and inclusion. First and foremost, my topic is focusing on disability rights in religious schools and the fight for full tuition. So everything begins with the IDA, which is the Individuals with Disability Education Act. Thank you. So imagine a child with significant learning needs. Their parents seek a free, appropriate public school education from their local school district. and their school district fails to offer them anything appropriate. They avail themselves of their right under the law, which entitles them to place their child unilaterally at a private school, private special education school, and seek tuition. The school district, in response to that, indicates that they're willing to settle, acknowledging that they failed to offer anything appropriate to meet the child's needs. That being said, in the same breath of saying we're interested in resolving this matter, acknowledging that, the failure to offer something appropriate, they also indicate that they're only willing to pay a portion of the tuition that does not include anything attributed to religious classes or anything involving the religious classes. Then puts the question of what's happened in the past versus where we have started to where we are now. My typical disclaimer being that I'm an attorney, this is only for informational purposes. So starting with the IDA framework, the Disabilities with Education Act, it surrounds three important questions. The first question, did the district offer a FAPE, free appropriate public school education? If yes, the inquiry stops there. If not, the inquiry goes on to, was the unilateral placement that the parent chose as a result of that failure to offer something appropriate to meet the child's needs, reasonably calculated to enable progress? And then the third question, are equities satisfied? I point out that in that test, the three-pronged test, religion does not appear in that question. Most importantly, religion, what the IDA does not provide is an automatic mechanism for reimbursement. Doesn't provide parental religious preference or funding religion as a matter of policy. Instead, if the district fails to offer a FAPE and parents unilaterally place their child in a private special education school, the question, and the only question that's relevant, becomes educational appropriateness. But for decades, neutrality was misunderstood. The misunderstanding of neutrality was the assumption that public funds could not support religious instruction. The result, religious schools were treated as per se, and I say religious private special ed schools, were treated as per se inappropriate. The practice, at least in New York City, the practice was tuition carve-outs and percentage reductions, looking at the child's entire schedule, picking out which classes were considered religious in content, and slicing and dicing that tuition, forgetting about the bigger question, which was, did the district offer free appropriate public school education to that student? The legal question was not whether the school is religious. It's whether the student is receiving an appropriate education. Nothing under the IDA says that schools must be non-sectarian. Congress deliberately intended to choose neutrality as part of the statute, allowing states to choose if schools could be religious or not. But neutrality under the statute for years, in this context and in this scope, was viewed as a prohibition. There were concerns with Establishment Clause, concerns with the understanding and belief that if a school district decided to settle a matter, or even if a case went to hearing, that a judge could only award tuition that reduced any carve-outs for religious classes. This was an overcautious interpretation for years, ignoring the other side of the constitutional analysis, which was the Free Exercise Clause, which forbids exclusion on the basis of religion. The tide began to shift. These cases, Espinoza, Carson, Loftman, all represent this understanding that the categorical exclusion on the basis of religion is considered constitutionally suspect, and began to reframe and rethink how IDA cases should be viewed. These cases reframed the law, the religious neutrality aspect, Neutrality means inclusion, not exclusion. Once a benefit exists, whether it's a scholarship offered by the state or whether it's IDA funding because a district failed to offer a free, appropriate public school education, they can't deny that benefit on the basis of religion. The key piece, neutrality and private choice on the part of a family, does not mean that if a school district resolves it through a settlement or it goes to hearing and it awards full tuition, that anyone's promoting religion. Rather, it's supporting equal access to education. So what does this not mean? These cases didn't stand for this notion under the IDA, even more so, that religious schools are automatically reimbursable, or religious private special ed schools, to be specific. Parental preference alone doesn't warrant reimbursement. Religious instruction replaces academic requirement. That's not provided under the IDA. Nor did the IDA relax its standards because of these cases. The IDA still requires proof of appropriateness and documented progress. What the IDA does not permit, and the interpretation of these cases, is that categorical exclusion is not permitted. So the common concerns, as previously stated, was that this notion that if you use public funds to support religious instruction, that was a concern on the part of school districts. If there was any payment for religious classes, it looked or appeared as though the government was endorsing the religious classes and the religious instruction that parents chose as a result of the district's failure to offer something appropriate. So what do these court cases really interpret, and what they respond to is that this is neutral reimbursement work. It funds through parental choice. Educational analysis is the first question and the last question, and the only question. And religious content is not attributable to the state. Reimbursement is a neutral benefit routed through parents and evaluated under IDA, under educational analysis, and analysis only under the educational aspect. So, for years in New York City, if FAPE wasn't offered by the school district and parents unilaterally placed, as they are entitled to do so, at a private special education school that happened to also be religious, well, they were faced with a dilemma. It is always a risk on the part of a parent who unilaterally places their child in a private school. And that risk is a risk that every parent would have to undertake. But the difference was that if a parent chose to unilaterally place their child in a private special ed school that happened to be religious, it was a larger risk. That risk was that they were not entitled or guaranteed that they would get full tuition because of these carve-outs, these percentage reductions. It was happening for years. And private, Jewish, or any other religious special education school were treated as per se inappropriate because of those carve-outs and those percentage reductions. After Carson in 2023, the state review officers, which is the second-tier review in New York for any appeal on the administrative level, you started seeing reversals. Reversals basically finding that when the lower court or the lower administrative hearing officer found that FAPE wasn't provided, that the unilateral placement that was chosen by the family was appropriate, was meeting the child's needs, but also happened to be a religious special education school, that they found was appropriate and that equities favored the family, they were reversing decisions that carved out those percentage reductions. And the SRO was starting to award full tuition. The focus returned to the question, and the only question that it should have always been, which was the educational substance. It was a routine practice in New York City and among many states that schools wouldn't pay for the religious aspect or the religious portion of any private special education school. Public money and religious schools wouldn't mix, and that was That was how the trajectory started. So, the impact. What changed? These cases started calling out no categorical exclusion. Religious status alone can't justify exclusion. What was the impact on these cases and on the IDA context? Focusing on educational substance, no categorical denial. Reevaluating unilateral placements in religious private special ed schools, because that was the only important question from beginning to end. And then there was what I would refer to as a landmark moment, a Southern District of New York case. A case was litigated at the administrative level, where the parents had sought a FAPE from the New York City School District. The district appeared at hearing, didn't put on a case, didn't try to defend what they offered. It then shifted to the parents to establish that their unilateral placement, which happened to be Sinai Schools, a private special ed school and an accredited special ed school in New York and New Jersey, was appropriate to meet the child's needs. There was extensive testimony presented through the parents and their attorney on the record as to what the child's deficits were, what the child was learning, what the child's schedule was, what the child was learning both in their core academic classes as well as their religious classes, showing the most important question, which was the needs of the child that were being addressed through every one of those classes. The IHO in that administrative hearing simply awarded partial tuition, reducing it by the tuition carve-out. The DOE, at that point, in their mind, they prevailed. They got what they wanted. It was a tuition carve-out. The parents at that point decided they were going to appeal. They appealed to the state review officer, and in that instance, the state review officer found that there was, that full tuition should be awarded, that there was no violation of the Establishment Clause, and went into more specifics about the record and why the unilateral placement was appropriate to meet the child's needs, not just in math, reading, science, and social studies, but in Judaics, Jewish history, and other religious classes, and then awarded full tuition. New York City then decided, well, that can't be, so they appealed the case to the Southern District of New York. And in that landmark decision by Judge Clark, determined that the SRO's decision to award full tuition was appropriate, finding specifically that religious instruction may be reimbursable, gave deference to the SRO regarding the analysis of the appropriateness under prong 2, and determined that there was no Establishment Clause violation. This was a landmark moment because it was the first time in the IDA proceeding that a Southern District of New York case established that it was okay to award full tuition for a religious private special ed school where the parents were deprived of a FAPE for their child. So, why did the parents win? How was religious instruction evaluated? It wasn't evaluated on the basis that, oh, it's the private special ed school and therefore appropriate. It went into all these different factors: text study, strengthening decoding and comprehension, focusing on skills. Written responses improved expressive language skills. The multi-step analysis reinforced executive functioning skills, and it went on. Because progress was documented in the academic texts. It was not just because it was reading or math, but the child was learning to express, to read out loud in every single class. It didn't matter if it was reading or if it was Jewish history. Appropriateness was determined by the skill acquisition on the basis of the child's disability. Parents prevailed, and the record was clear. Parents didn't win because of those religious classes. They won because the record supported academic instruction, supports transferable skills, and documented progress. The record documented in Judaic classes developed the same literacy, reasoning, and academic competencies that were taught in English, history, and math. And these skills were being worked on strictly in direct response to the child's area of deficits. The Southern District case signals, right, that the district must update their practices. This notion of tuition carve-outs and percentage reductions when the district fails to offer an appropriate public school program for a child is not okay. And it goes on and it talks about what the IDA's framework was and continues to be. No, there's no automatic entitlements. IDA still controls. So what does this mean going forward? Well, districts should not just categorically exclude religious private special ed schools. There shouldn't automatically be these carve-outs and percentage reductions. Parents are still required to establish the appropriateness of their unilateral placement, transferable skills, and meaningful educational progress. But the Southern District of New York case is considered persuasive authority. There was no appeal, naturally, by New York City to the Second Circuit, because that would, if in fact was an appeal, would be favorable to families and it would be precedent. So at this point, the appellate guidance remains open. The legal landscape continues to evolve. But what we need to be reminded of is that the IDA is the governing standard in these cases across the board. And that this case represented, the landmark case represented this notion that categorical exclusion is prohibited. And the only analysis, and the only important analysis, is whether or not the district offered a FAPE, and if they fail to do so, that the unilateral placement chosen by that family is appropriate to meet the child's needs, regardless of whether the child is learning it in reading, math, history, or Jewish history, or other religious classes. Thank you.
Thank you so much. And this case has received nationwide attention. And I really appreciate your discussing it so thoroughly. Our next speaker is Rabbi Itamar Rosensweig, who has spoken here also many times and also published with the Law Review in virtually every year during the last, I don't know how many years, I can't even remember, so many, but too many to count. Professor Rosensweig is a professor of Jewish law and jurisprudence at Yeshiva University. He is also a rabbinic judge at the Beth of America and is a professor of philosophy as well at Yeshiva College. He's the chair of Jewish studies at the YU Cy Sims School and has a very distinguished background in terms of the breadth of the areas he studied, from physics, philosophy, Jewish law, and Jewish history. So, Rabbi Rosensweig.
Morning, everyone. Thank you to Professor Levine for organizing the conference and Professor Seplowitz for moderating. It's always great to have a chance to come out to the far end of Long Island, especially traveling from Philadelphia. So as long as Amtrak and the Long Island Railroad are running, so we can keep the conference going. So. Okay, this morning I want to speak about disability rights and inclusion from the perspective of Jewish law. I want to tackle the topic from a philosophical perspective. I want to provide a framework for thinking about how Judaism and religious law generally should engage with the conversation about disability rights and inclusion. Now, the first idea I want to develop is that this question falls under a subset of discussions about distributive justice, which is how a government or society should distribute goods and resources to members of its community. And we could think of goods and resources in terms of economic goods, money, wealth, property, possessions, but we'll speak also about the distribution of moral goods, which I'll get to in a second. Judaism itself is very interested in questions of distributive justice. Most well-known is the idea of distributing financial assistance, the idea of tzedakah. In years past at this conference, I spoke about how it's in Jewish law, the idea of distributing financial assistance is not just about the economic aid, but also about distributing dignity and making sure that the recipient is given proper recognition of their human dignity. So I'll give an example from Jewish law. So the rule is that a person is entitled to assistance not just at the financial level, but say, for example, that their spirits are low, they're depressed, or they're lacking a companion, then the same principles of financial assistance also require that we provide them with something that's going to raise their spirits or that will give them proper encouragement to be productive or to be happy. Another example in Jewish law that we spoke about in years past is the idea that it's preferable to give somebody in financial straits to give them a job than to give them financial assistance, because a job allows them to feel their own sense of productivity and to earn a living with proper self-esteem. So that's an example where it's the distribution of dignity that accompanies the rules for the distribution of financial assistance. John Rawls, in his Theory of Justice, talks about how one of the key things that society should distribute is the social bases of self-respect, in addition to income and property. So you want to make sure that all the members of society have what it takes to have self-respect for themselves, which is another way of saying that distributing that moral good is required by distributive justice in addition to the distribution of economic goods. Now, I want to extend that point to what's at the heart of this conference, which is to say that inclusion is itself an important moral good or a social basis of self-respect. So it's important for society to ensure that all of its members feel included in social groups or in the political social organization that it creates. And that itself is required by the notion of distributive justice. I'll give an example from Jewish law. The prophet Isaiah, this then gets codified by traditional legal sources in Judaism. It says, you should bring the poor, the oppressed poor, into your home. And then this gets codified in the Mishnah. It says, the poor should become members of your household, which is a point less about financial assistance and more about inclusion in your own table and your home. So we have this idea of inclusion as an important social good that should be distributed. Now, I want to now pose the following question. When we think about the idea of inclusion, or inclusion as a good, is it better for us to think of it as a right that a certain member is entitled to, or is it better for us to think of it as a duty that society has to accord, to grant to someone in need? Now, I want to give a little background to this distinction. It's often said, we had a conference a few years ago about the thought of Robert Cover. It's sometimes said that religious language, especially Jewish language, the language of the Hebrew Scripture, speaks in terms of duties, and it's organized around obligations. So, you're commanded, don't steal. You're commanded, don't murder. You're commanded to give financial assistance to someone. Whereas Western legal systems are organized around the ideas of rights, which is the entitlement of the recipient. So it's thought that this reflects two different ways of organizing society. You could have a rights-based social order, or you could have a duty-based social order. And some theorists, maybe Cover among them, believe that this reflects fundamental disagreements. that these two different ways of organizing society reflect different value systems at bottom. So for example, Cover says that Judaism, at its moral foundation, is about obligation, maybe obligation to God, a sense of commandedness, whereas Western civilizations are at bottom about the liberty of individuals, the rights that they contain to be free. And so then, in America, we organize ourselves around rights, a right to education, a right to healthcare, feminist rights, disability rights, because we're thinking about the entitlements of the recipients, whereas in Jewish law, the ideas are organized around the duties that are incumbent on the duty bearer, the commanded person. Robert Cover, in his article, criticizes some of the rights-based discussion, and he says, for example, that oftentimes rights-based rhetoric is empty. So he says you could speak about a right to health care, but if you don't assign the duty to provide health care to someone, then the right is empty. And you could say everyone has a right to education, but until you assign who has the duty to provide education, so that the right is really empty. And same in disability rights, you might say people with disabilities are entitled to, but if you don't assign what are the duties that other people have to ensure that those needs are taken care of, then the rights-based rhetoric is lacking teeth. So Robert Cover makes a big deal about that point. I want to make the following. I'll mention also there's a scholar in Israel, Benjamin Porat, who published a piece recently in the Oxford Handbook of Jewish Law, which responds to some things that Shua Mermelstein and I, who spoke here at the conference, we published in the Touro Law Review. And so there he responds to an article in the Touro Law Review, and he says that, in his opinion, there are more fundamental differences between rights-based civilizations and duty-based civilizations. He, for example, says in this piece that rights-based civilization is more prone to speak in terms of negative liberties, which is like the idea that I shouldn't interfere with your property holdings, whereas duty-based civilizations are more prone to speak in terms of positive liberties. I mean, like specific things that you have the powers to do. And this is supposed to trace two different ways of thinking about moral rights, and he has some interesting examples about how the systems differ in tricky ethical cases as well. But what I want to argue in today's presentation is that fundamental distinction between these two different types of societies is mistaken, and we should really distinguish between legal rhetoric, legal language on the one hand, and the moral grounds of law on the other hand. So what I want to suggest is that it's true that religious language speaks in the language of duty and obligation, but that's a matter of legal rhetoric. It doesn't capture the moral grounds that underpin the law. So it could be that, for example, Hebrew Scripture and the Bible will speak about the obligations incumbent upon the duty bearers, but that's simply because that's a good way of organizing society where somebody is animated to fulfill the duty that they have. So you might say, I have a duty to educate my children. And that's more socially advantageous than saying that my children have a right to education. Because now I am moved to satisfy the duty that I have. Cover gives that example. A duty can't be empty in that sense. But it still may be the case that the ground for my duty is the right that my children have to an education. And in the case of disability and inclusion, it could be that as a matter of legal language, the law should be formulated as an obligation that society or members of society have to include all of its members, but still the basis for that duty, the moral ground, is the right of the person who's entitled to it. Now, I want to explain why I think that distinction is important. I think if we just focus on obligations and duties, then you lose sight of what appears to be the true moral basis for the obligation. So I'll give you an example. If I speak of financial aid in the Jewish law discussion of tzedakah, of financial assistance, as simply an obligation that I have, then it's true that I'm moved to discharge that obligation, but I'm almost indifferent to how it affects or changes the well-being of the recipient, because you're focused on the discharging of your obligation. Whereas, when you think of it in terms of a claim that's made by somebody who's entitled to assistance, then you think about how their life makes a claim on you. In fact, some of the theorists who like the idea of religious law being formulated as a duty imposed on someone who holds an obligation, they like it because they like the idea of religious law as essentially God's commands obligating individuals. But the risk there is that if a person sees the command as the basis of the obligation, then they're indifferent to the moral entitlement of the person who is the object of that command. So maybe God commands me to assist someone. So is my duty owed to God, or is my duty owed to the person I have to assist? Now, if you just speak in the language of duty, you could forget that the person in front of you is the person who has that moral claim against you. So I want to flesh this out a little further through the paradigm of moral recognition. In some contemporary discussions of distributive justice and the equal worth of human beings, it's sometimes said that a failure to recognize someone's moral status is a failure of justice, because you're not recognizing what type of thing they are and what type of moral demands their life and existence makes on you. So it seems to me that's a very important piece of understanding religious law as well, that in the case of, say, for example, inclusion, there's something about the person who is entitled to be included, something about their moral status that makes the claim against you. And if you fail to recognize that, then you fail to recognize the type of moral creature that they are. So it seems to me that we could harmonize the observation that somebody like Robert Cover has, while also appreciating that rights do have a central place in religious thought. And the way to harmonize those two different ideas is to distinguish between the language of religious law, which assigns and speaks in terms of obligation because it has certain advantages, versus the moral ground, which may still be the rights and the entitlement of the person to whom you owe the duty. I want to close with the final thought that if inclusion is itself a good, a social good that should be bestowed upon all members of society who are rightfully entitled to it, then failing to recognize someone's right to be included is a failure of distributive justice. And it could be argued that the only way to properly recognize someone's moral standing is to understand that it's their right that gives rise to the duty that you have to include them. Thank you.
Thank you very much. I'd like to open ask the audience for questions. Yes. Okay.
Hey, thanks. That was terrific. Let me ask Rabbi Rosensweig a question. I think I followed the logic to focus on both obligations toward certain persons, including persons with disabilities, and we can also think of that as joined with a conception of rights that those yeah.
You hold the microphone a little closer. Yeah.
Yeah, sure. So obligations toward persons, including persons with disabilities, with a particular application on inclusion. And then we can also think on the flip side as a right to be included. But I think there's another part of the moral ledger that could be and should be filled out, which are the obligations of those persons, either thought of as rights holders or persons to whom obligations are owed. So it's not always true or clear that those persons have an obligation that's conjoined with a right. So sometimes they do, like we have both a right to be included in a jury and an obligation to serve on that jury. But that is less true, or at least more controversial, with respect to, for example, work and employment, and also joining. So we have entitlements, rights, that's conventionally understood, to opt in to join, but not an obligation to join. So I'm wondering, Rabbi, if you could speak some to the obligations of those with disabilities and others, if any, either moral or legal, that is another aspect of the moral universe, not just the right to be included and not just the obligation to include, but sometimes an obligation to join or to work or to contribute or whatnot.
So you're asking, if I understand the question, you're asking what obligations do the persons with disabilities have towards society generally? You know, in philosophical language, there's a question of full moral status. You know, what is the basis of someone having moral status? And then from there, usually the thought is that a person with moral status has the same obligation to be a member of society that anybody else has, unless there are extenuating circumstances that would defeat the obligation. So to me, the question of having a moral entitlement flows from having proper moral status, and which would ground the entitlement to be treated a certain way. And to the extent that a person has full moral status, then they also have the similar types of obligations to society at large, unless it's defeated by some sort of extenuating circumstance argument. So I think having a right presupposes moral status, and then that same idea of moral status also makes somebody obligated towards society as a whole. Thank you.
Hi. So my question is kind of stepping back to the administrative process we talked about with the New York Department of Education. And I was wondering if there's been any sort of impact litigation or other administrative litigation around the structure of the process. So my firm has been involved in some of this litigation revolving around administrative law judges and whether the Constitution grants certain powers to those judges. And I was wondering if there's been any sort of scholarship or litigation around the powers of these hearing officers, and just hearing about this process of you have your initial negotiations with the school, and then there's a hearing, and then you have another hearing, and then you're in SDNY. I was just thinking to myself that it almost seems like that process is more expensive than actually just granting the accommodation that the student deserves, and just thinking about, like, is there a way that the burden of persuasion or proof needs to be changed to reconcile that. But I think my core question is, has there been any challenges to the administrative process itself, separate and apart from challenges within specific cases around those facts?
Thank you for your question. I would say for many years, the litigation of the special education cases was under the auspice or control of the impartial hearing officers, which were appointed by the state, but essentially also employed by the Department of Education. And then in the last few years, as a result of the huge backlog of these administrative cases where parents were waiting for extensive times for decisions by hearing officers, the cases moved from the impartial hearing office essentially to the oath office, where you have oath hearing officers who come from all walks of life, not necessarily trained or experienced in special education, who now hear these cases, and are moving through them a lot quicker. But also, there are pros and cons to that. So while some of these decisions are moving quicker, the expertise of the impartial hearing officers who were only dealing with special ed matters is now missed in that regard. You have ones that now deal with all areas of law. There is also this notion of, because there's a second-tier review in New York, there's a huge backlog now in the state review officer level, where there is decisions that we are hearing that are on appeal from September, earlier, before the summer. So now there's a backlog. So while there is an initiative to change the backlog at the administrative level, now there's a huge backlog at the state review level. So that is the extent or the trajectory of how things have changed. I am not aware of anything specifically right now dealing with the backlog at the state review level, but when this happened many years ago, there was a lot of pushback, and the state review officer was then charged with hiring more people so they can listen to these appeals and they can decide these appeals on a timely basis. It's unfortunate that families who are looking for immediate results are not able to get what they're entitled to under the law, and these compliance timelines are going through the roof.
Any other questions?
Yes, I have a question specifically about in the educational space. If I'm not mistaken, that 2023 case you're referencing, the challenge was to the vouchers, right, generally, and how they were giving money to religious schools. And I love the way that it's been leveraged to expand accessibility for children with disabilities. But I'll go to my jurisdiction where voucher schools, I live in Arkansas, the vouchers actually exclude children with disabilities specifically as overly burdensome to the schools, right? Mind you, the schools, the last report was like over $100 million collectively. They have, been given from the state through the voucher system. So how do we balance the fact that, or do we leverage, right? Do we make it like you need to provide the service because you're getting state funds? Or is there a different argument that should be leveraged so that they do equally accept children with disabilities?
So that's actually a really interesting question. I mean, my focus has always been under the IDA, right? And so because of that, it's a standard framework, right, for all families. District offers a FAPE, that's the duty. That's what their districts are charged with, evaluating timely, staying within compliance timelines, offering an appropriate program, offering an appropriate placement. And ultimately, if that district fails in that regard, and the parents choose to unilaterally place under your prong 2 analysis, the only question is whether or not the unilateral placement is reasonably calculated to meet the child's needs. So, I mean, it really doesn't get into the constitutional analysis, to be quite honest, because these other cases that you're referencing were specifically, right, targeting certain groups. Well, if you're a religious school, or if you're looking for a religious, a service within a religious school, it targeted. But the IDA is neutral. It doesn't target religious, non-religious. It talks about the duty to provide an appropriate education, and then when that failure happens, inclusion, right? Inclusion, meaning if you unilaterally place your child in a private school, you're doing so, and that it shouldn't be treated differently, you shouldn't be treated differently because you chose a private special ed school that includes the religious aspect. So it doesn't really even get into the constitutional analysis, and I'm not even an expert in the constitutional piece. In fact, when the case was appealed to the Southern District of New York, it was handled by a firm specifically only on the constitutional question. So I think your question is a really good one, and I'd be interested in speaking probably offline more about what's going on in your state specifically. Crazy. Yeah, it sounds like it.
So thank you both for these really interesting and inspiring talks. And mine's also related to the students with disability piece, but I come at it from a different perspective. I'm not a disability lawyer, but I've been teaching constitutional law for a pretty long time. And there's an aspect of this that I do think is worth at least collectively thinking about as members, most of the people here, I'm assuming, of a minority religion, looking simply at Carson v. Macon without also looking, for example, at cases like Kennedy versus Bremerton School District, I think fails to allow us to appreciate that for a very long time in the American constitutional law tradition, there's been an acknowledged tension between the free exercise clause and the establishment clause. And there's been a willingness to allow regulators to appreciate that eventually there can be tensions in the administration of laws that by furthering the objectives of one of those clauses may run up against the other clause. And I would simply suggest that I thoroughly admire your advocacy, but to claim that it's a categorical exclusion, to disallow a discount for religious instruction in a private school, in my opinion, disallows an appreciation of the accommodation regulators inevitably confronted for a very long time between the potential conflicts that's often realized between those two First Amendment clauses. And what's happened in our recent jurisprudence is that this Supreme Court has taken the free exercise clause, joined it with the speech clause in an effort to subordinate the establishment clause. And I'm not convinced that that's necessarily in the long term beneficial to members of a minority religion like ours. And so I just put that out as a cautionary note, because even though my comments don't come from a disabilities expertise, I really am concerned about the directionality of this jurisprudential move as a member of a minority religion and as a law professor who teaches constitutional law. So thank you.
Thank you.
There are many more questions, and I actually had a very brief question, if I may, to Rabbi Rosensweig. You mentioned and alluded to duties and rights and duties that are to God, and then duties that are to individuals. And we just saw that last week in terms of the paradama, the duty that doesn't seem to have any rights associated with it. Is it possible, with respect to duties to others, that we can really separate out rights? Aren't they necessarily correlative? In other words, the duty to treat the rich and the poor equally, not favor one over the other. That duty, without the understanding that it is used to include the poor and the rich together and achieve equality, seems to me to be part of that duty too, and we should appreciate that.
I'll say it in the American tradition. So there's a piece by Wesley Newcomb Hofeld,
Right.
where he makes the case that claim rights are correlative of duties.
Right. Very descriptive.
Right. So to have a claim right against somebody is to say that they owe a duty to you. But you could have other frameworks. Joseph Raz has one in the Morality of Freedom, where the basis of your duty is a right that somebody has. So it may be that as a matter of discharging the right or claiming the rights, discharging the duty or claiming the right, they're correlative. So my duty is correlative to your right. But there's a separate question about which one grounds the other. So it could be that there is something morally special about you that generates the duty of assistance in me, right? Whereas you could have a different theory which thinks almost that it's my duty that almost has this strange, almost coincidental consequence that you happen to get a right out of it. So you could think that I have a duty of charity owed to God, and then you happen to be the beneficiary of that duty, but then it's the duty that grounds the right and not the other way around. And I do think that a lot of religious thinking is, I don't want to say frozen, but it is framed in terms of duty-based obligations without appreciating that there may be rights of individuals that ground them. And that's a big part of religious language. But the point that I'm making is that the language of the law doesn't necessarily reflect its moral architecture. So it could be that the law is recognizing rights that exist, and it's imposing duties on that basis, and not the other way around.
Thank you very much for a wonderful panel.
Thank you.
Thank you for a terrific first panel to start the day. And in just a moment, we will begin our international panel. If the next panelists would please approach the front.